YouTube. Good evening to you all. It's the World Record Webinar Series run by Shri Kumarswami Mahavidyalaya Ausa, District Latur, Maharashtra State. Today is the 266th day of this series, which was started as a second part on 7th March as a Women Empowerment Day. Today, invited resource person Dr. Shivani Verma Madam, who is Assistant Professor, Law Center 1, Faculty of Law, University of Delhi. Welcome you, Madam. She will speak on the topic sexual harassment at workplace, prohibition, prevention, and redressal in law. As we are knowing that in every office there are women, they should be safe and they should be treated respectfully. There should be no any harassment of her on any level. If such unfortunately happens, then how law supports us? What are the provision of it? She will speak as a professor of law. Thank you, madam. Welcome to this webinar series. You can start your speech. Thank you.
Thank you so much, sir. Thank you for giving me this platform. I hope I'm audible.
Yes, you are audible, madam.
Okay, so I will be presenting my thoughts through with the help of a PPT basically. So I'm going to share my PPT first, and then I'm beginning with my topic for the day. So as sir has already told you, the topic which I am going to discuss today is sexual harassment of women at workplace, prevention, prohibition and redressal act, which is a law which was enacted in 2013. So before we start talking about the intricacies of this particular legislation, I would like to tell you all a brief about what was the objective of the legislation, what was the thought process with which this legislation was primarily enacted, so that we can understand the spirit behind it, so that we can understand what exactly the lawmakers wanted to achieve through enacting this particular legislation. So there is this graphical depiction which says that we need gender sensitization. We need people to be aware that women are facing lot many challenges, and in order to bring women from that marginalized column to the mainstream society, it is very important that we educate our girls. And after education, it is equally important that they work so that they are economically independent. Now, the moment we talk about giving work opportunity, giving economic independence to our women, the most important thing, or rather the challenge which is there in front of all of us, is what sort of environment we want to provide our girls, or we want to provide our women, in order to give them a safe environment. They will come out, they would start working, but they wouldn't feel comfortable till the time that whole work environment is not gender safe. So if at all we want to attain the ultimate goal of gender equality, the first step is economic independence. For economic independence, the first step is create education places which are safe, and create workplaces which are safe for women to work. And for that, this POSH is one such tool which creates such environment where there is no scope for any sort of sexual harassment of women. So the ultimate aim was gender equality prevail karna, and in order to prevail that gender equality, economic independence or safe work environment अपनी women को provide provide karna. That was the spirit behind it. So if we go to the background, the history of Posh Act, it started with a very unfortunate incident. Whenever, the way I was talking earlier also, we wanted our women to come out and work so that they are economically independent. One such work opportunity was provided to certain women from the side of Rajasthan government. So Rajasthan government women's development program was there, for which they recruited certain sathins, the workers basically. They were called sathin. And Bhavri Devi was one such worker who was working for this particular program of Rajasthan government. So what exactly these women were doing? They were creating awareness. They were trying to find out whether there is female feticide happening. If at all there are ways to prevent it, they were working towards it. Similarly, they were also trying to work to prevent child marriages. So this Bhavri Devi, she came to know that there was one girl child, only 9-month old girl child, जिसकी शादी की जा रही थी. So this woman basically tries to stop that child marriage of that 9 months old girl. And the way it is in our society, the only way to stop a woman is harass her sexually. The same thing happened with Bhavri Devi also. She was molested, she was harassed, and ultimately 5 men from the community for which she prohibited, she tried to stop that child marriage. Same community men, they raped Bhavri Devi. So this case was particularly taken up by an NGO, and they went to Supreme Court asking that this is not the way women are going to come out. This is not the way that women will feel safe and would come out and work. We need to do something to provide an environment to our women that if at all they start coming out, they feel safe. If in every office, everything they do, the revenge or the mechanism to stop them from working would be assault them, rape them, harass them, then how can you expect our women to come out and start working? So the cognizance of this matter was taken up by the Supreme Court, and Supreme Court laid certain guidelines which are commonly known as Vishakha guideline, one of the most landmark judgments and one of the most well defined guidelines through which Supreme Court made an effort that let's provide our women a safe place to work. Let's provide an environment to our women where they wouldn't be sexually harassed. So this is Vishakha guideline, and Supreme Court says that if a woman is sexually harassed, this is not violation of her body. That obviously is there, but before violation of her body, it is a gross violation of basic human rights, basic fundamental rights as provided under Constitution under Article 14, 19, and right to life as propounded under Article 21 of the Constitution. The court also directed the government of India to frame guidelines so that even if there are in future such kind of cases, they come, we must have a mechanism to dispose of such cases. And before you derive a mechanism to dispose of such cases, the first thing was, first of all, let us define what exactly, very particularly defined sexual harassment at workplace. It was also held that we need to spread awareness and information about sexual harassment at workplace. Every act of harassment must be redressed through criminal proceedings and through disciplinary proceedings also. And most important thing is that redressal is not enough. An effective and time bound redressal is necessary. So that's the reason that Supreme Court gave guidelines that we need to derive a redressal mechanism which is very time bound and provides effective redressal to any sort of complaint by a woman for the matter of sexual harassment at workplace, for which a complaint committee was suggested by the Supreme Court that every office, every workplace must have a complaint committee so that the redressal mechanism is approachable, is effective, and also time bound. And the women who are being harassed at the workplace, they get effective remedies against that. So these were the Vishakha guidelines, the basic foundations on which POSH Act ultimately was built. But what happened? These guidelines were propounded by Supreme Court in 1997. Until 2010, there was only a bill which was pending. There was no enactment, there was no concrete legislation which was drafted by the government, and hence Medha Kotwal Lele again went to Supreme Court in 2012 and asked the court to again intervene. Asked the court to ask the government that after 1997, this is 2012, where is the legislation? Why are we still having a bill only and not able to enact any effective legislation after so many years of Vishakha guidelines? So it was after Megha Kotwal Lele versus Union of India, the case that ultimately only 6 months were given to central government, and finally after these 6 months in 2013 we got our legislation which is called as Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act. So as the act itself is, the name itself is reflecting, it talks about three things. It prevents sexual harassment of women at workplace, it prohibits the sexual harassment of women at workplace, and also if there is any matter of sexual harassment of women at workplace, this legislation talks about redressal. So there the legislation basically is three dimensional: prevent karta hai, prohibit karta hai, and also provides redressal for all sort of sexual harassment of women which happen at the workplace. So now let's understand the legislation with bit more intricacies involved. So there are five essential duties. If you go through the act in comprehensive way, you will find out there are four duties which are levied on the employer. First of all, the employer will have to formulate a posh policy. They need to establish a posh committee, which will be an internal committee, a very approachable committee, wherein all the women worker can go and file their complaint of sexual harassment. Then it is equally important to make the employees understand what exactly is sexual harassment, what exactly is the behavior which is questionable, what exactly is the behavioral corrections which are required. You need to correct your behavior, you need to understand what is harassment. So for all that, it is employers responsibility to organize awareness campaigns, also to create awareness, to tell the employees that this is allowed, this should not happen. Then organize posh committee trainings also. And then it is also very clear directive that every internal committee would submit a posh annual report, to an extent that if someone is not complying with all these five essential duties, in the case of Mrs. Arvinder Bagga versus Local Complaints Committee, the court imposed a penalty, 50,000 rupees fine on Medanta Hospital Indore, because they did not comply with these essentials duties which are laid down by POSH Act of 2013. So every workplace has to have these five things, duties as for the employers, laid down by POSH. Then the first thing we need to understand whenever we talk about sexual harassment is what exactly is sexual harassment? What conducts are defined as the harassing conduct? What is allowed and what is not allowed? It is very important to understand what behaviors will be called as harassment behaviors. So section 2N, clause N basically talks about the definition of sexual harassment. So if you go through this definition of sexual harassment, and I'll explain it later, it has many parts involved in it. So when you start reading the section, it says sexual harassment includes any one or more of the following unwelcomed act or behaviors, whether directly or by implications. So first thing first, you need to understand it is not the direct behaviors only, it is not the direct acts only, but also the implications of the act, the indirect effect of the act can also be harassing. So you cannot take a plea that I did not touch. Even that one giggle, even that one look in the eye is enough to constitute the act of sexual harassment. Then there are certain conducts which are given in the definition itself. Few of them are physical contact and advances. Definitely, you cannot touch a woman physically or take any unnecessary physical advances from a woman. You cannot make a demand or request for sexual favors. Definitely, it is harassing. You cannot make sexually colored remarks or showing pornography. Again, is sexual harassment, or any other unwelcome physical verbal or non-verbal conduct of sexual nature. So when you study, when you read section 2 clause n, there is one thing which is the underlying bottom line, and that is unwelcomed act. So it is only and only the woman who decides what she welcomes and what she does not welcome. So, if a woman says no to any of your behaviors, it is clearly an indication that whatever you are trying to do is unwelcomed. She's not okay with it. And that is the ultimate test. You might have your explanation that it was an innocent comment. No, I did not mean that. No, I was saying something else. She understood something else. No, it is her idea of what she's okay and what she's not okay with, which is going to define sexual harassment. So any plea from the side of respondent zeroes down to one thing: whether the female, the woman who is the complainant, welcomed it, was okay with it, or she was not welcoming it. It was an unwelcome act. So unwelcome is one criterion which would help the committee, also whoever is deciding the matter of sexual harassment, to come to a conclusion which actions would fall under section 2n and which action would not fall under the category of sexual harassment. Then same section in M clause defines respondent. Respondent means a person against whom a grieved woman has made a complaint under section 9. So section 9 is the section which talks about that if there is any woman who is being harassed at the workplace, can go and file a complaint. So against a person against whom basically this aggrieved woman files a complaint is called as respondent. Just a second. So as I was saying, that respondent is the person against whom the complaint is made. There are certain new judgments given by the court which defines the meaning of respondent. One of the very procedural and very advanced kind of judgment is in the case of Malabika Bhattacharya versus Internal Complaints Committee. And here in the court said, the Calcutta High Court, to be more precise, said that same-sex harassment complaints are also maintainable. Till 2020, there was an understanding that respondent is always a male. Respondent has to be a male. So it is prevention of sexual harassment in for women basically. So the complainant is always woman. The legislation is formed for women. So aggrieved party definitely is going to be a woman. But before 2020, the understanding was that against the person whom you are making the complaint, that respondent needs to be a male. But after 2020, Calcutta High Court judgment, the same-sex harassment complaints are also maintainable under POSH Act. This particular case was female versus female, and hence the committee said no, we are not going to take the cognizance of this particular case because a female cannot be a respondent. But after 2020, you need to keep this in your mind always, that same-sex harassment complaints are also maintainable under POSH. Then again, digital era is going on. People are working while sitting at their home. Work from home is something which is very much in these days. So when you work through your computers, when you are working sitting at your home, then how would you define workplace? Because this legislation is about sexual harassment at workplace. So if I'm sitting at my home, you are sitting somewhere in Maharashtra, there has to be some territory, some jurisdiction. How would we define workplace? So the court in Sanjeev Mishra versus Disciplinary Authority defined workplace also, that when you are working for same organization, whether I am sitting in Delhi, you are sitting in Maharashtra, it wouldn't make a difference. It would be considered as one workplace. So this is very progressive kind of a judgment which has widened the jurisdiction of the committees, of the kind of complaints that you can take. Same-sex complaints are also maintainable. Digital sexual harassment again is something of which the people can take the cognizance through ICC. Next is prevention of sexual harassment. as propounded under Section 3, no woman shall be subjected to sexual harassment at workplace. This is a rule. This is the basic guideline that in any case, no woman should be subjected to sexual harassment at workplace. And it is not only gestures, it is not only behavior, it is also the circumstances. The whole circumstance under which a woman is working can be very hostile, can be very harassing for the woman. So the act is not talking about the behaviors or the gestures, how a woman is touched, how a woman is looking, what sort of comments are being made towards that woman. It is the entire environment which has been taken care by the legislation. The act itself in the section 3 says the following circumstances among other circumstances. Again, सिर्फ यही नहीं, इसके beyond भी circumstances हो सकती हैं, but we have given certain circumstances, we have enlisted circumstances जिनको हम definitely sexual harassment बोलने वाले हैं. If it occurs or is present in relation to or connected with any act or behavior of sexual harassment, may amount to sexual harassment. Implied or explicit promise of preferential treatment in her employment, as in, you kindly come out for dinner with me and I will give you promotion. That is again a kind of harassment wherein you are creating a circumstance, then advancement are requested, then undue favor are requested, then any sexual demand is requested out of a woman. Implied or explicit threat of detrimental treatment in her employment. If you are not going out with me for dinner, I am not going to promote you, or I will transfer you to some remote areas. That kind of threats are again harassment. Implied or explicit threat about her present or future employment status. Let's say, अगर आप मेरी demands नहीं मानते हो, तो I am going to write a very bad reference, or I am not going to write a reference for you. I am not going to give you a work experience certificate. All those kind of things wherein a woman has to face different kind of harassments. Interference with her work or creating an intimidating or offensive or hostile work environment for her. Humiliating treatment likely to affect her health or safety. So first of all, 2N talked about behaviors, 2N talked about gestures, while section 3 talks about a broader thing. Section 3 talks about the circumstances, the environment which is created at the workplace, making it very difficult for women to survive and creating an environment wherein a woman always faces harassment or feels that she is being humiliated. Quid pro quo, this in return of that. And that is called hostile environment. मतलब या तो asking for sexual favors, you want promotion, kindly do this for me, sexually colored remarks, otherwise I am not going to transfer you, I am not going to promote you, I am not going to sign your appraisal. या फिर creating an overall hostile environment for women wherein they don't feel healthy, they don't feel safe while working in that kind of environment. So it can be direct behavior, it can be indirect behavior, it can be by creating a hostile environment. All of this in totality will be called as sexual harassment at workplace. Now, section 6 talks about when these kind of sexual harassment kind of things are happening in the office, what exactly is the redressal mechanism. The first thing is that you need to constitute a committee. So there are two kinds of provisions which talk about committees and how you are going to constitute and what is going to be their jurisdiction. First of all, section 6. Section 6 talks about a local committee. This local committee is something which is constituted at district level. So at district level, within this jurisdiction, within the jurisdiction of the local committee, if any case of sexual harassment happens and you don't have internal committee is committee which is constituted in the offices, to which we will be going after discussing local committee. So that internal committee has to be there in every workplace. If there is any workplace wherein internal committee is not there, then district level pe there will be a local committee. This local committee is constituted by district magistrate. This local committee will have a jurisdiction, and within that jurisdiction, if there is any incident of sexual harassment at workplace, any woman can approach this committee and file the complaint. And second case is there are internal committees. So local committees work when there are no internal committees, and second is internal committees. This is internal committee. So every office is supposed to have an internal committee. What is the composition of this internal committee? There would be one presiding officer who is going to be the senior level female employee of that particular office. Then there are going to be two employee members. Again, those members would be the member of IC who will have sensitization about the issue, who would understand how POSH works, who would understand what are the challenges faced by women at the workplace, who understand what exactly sexual harassment is. These kind of two employees are going to be the members of IC. And then in order to prevail that this committee works in an unbiased way, you have to bring in someone who is external, who is not working in that office, so that one external member again would be part of this IC, and that external member again must be someone who has experience, who understand what POSH works for, who understand again the causes for which IC would be working. So there are total 4 members, one presiding officer, 2 employee members, 1 external member. Out of these 4 members, in every proceeding, 3 members must be present. If there is any day wherein these 3 members were not there and yet IC proceeded, that particular proceeding would be questionable. That proceeding will not be considered to be a valid proceeding. So the quorum is that you have to have out of these 4 at least 3 members in every proceeding. This is IC. So local committees are where this IC is not present in the offices. Then there is second option to go to the local committee. I hope this is clear now. So there are 4 members in internal committees. So now let's say there is a matter of sexual harassment. First thing is, how would you reach the committee? What is the limitation period? Within what duration you are supposed to reach this committee? So if an IC is constituted in an office and a woman faces any kind of sexual harassment, there are 2 possibilities. One possibility is there is one single incident of sexual harassment. That's it. There is only once that she was harassed. So within that particular harassment ke baad, we need to count 3 months. Within 90 days of that incident, she has to file a complaint. Second option is when it is ongoing. Every day she's going to the office and she is being harassed by her bosses or by any fellow male colleague. Then in continuing cases of sexual harassment, last incident of harassment, whenever the last incident of harassment happened, we are going to count 3 months from that particular date. So limitation period is of 3 months. 3 months sole incident है तो उससे 3 months, continuing incident है तो last time जब भी हुआ उससे 3 months we are going to count, and within those 3 months the complainant, the woman, has to file a complaint in IC. There are times when women are not aware or needs to understand it. तो अगर 3 महीने बाद भी IC believes that the reason of delay was justified, after 3 months also a complaint can be entertained by IC. But rule says that within 90 days of the sexual harassment incident, the complaint has to file, and if at all there is any delay, that has to be reasonable. Now, who can file a complaint? So the woman who is harassed can definitely file a complaint directly. And then there are cases wherein the woman is not in a condition to file a complaint. Then any guardian on behalf of the woman can also file a complaint, and the committee would take cognizance of these kind of complaints also. Then while conducting the inquiry, the whole procedure is being laid down in the legislation, and there are certain rules also which we'll be discussing. So first of all, examination of complainant and respondent happens. Then there is cross-examination, re-examination, cross-examination of witnesses, and then the findings are prepared, and then the report is prepared, which is the final recommendation of the committee. So all these procedural requirements we are going to deal with now. So there are two roles that this single committee plays. The IC internal committee, it plays two roles. As per section 9, there are dual roles given to the committee. One is investigation and the second one is as an adjudicatory authority or inquiry authority. So first of all, when you file a complaint, IC goes into a fact finding exercise. They understand that whatever is written in the complaint, are the facts true? They want to fetch the evidences, they want the witnesses to corroborate that whatever is written in the complaint is true. So that is fact finding exercise. So first stage is investigation. Second stage is inquiry. This is where the IC would apply its brain and would try to understand which party stands correct, which party can substantiate the allegation, and whether the other party is actually guilty or non guilty. So there are two stages, and in these two stages, the mindset with which IC works is entirely different. During investigation, do not apply the mind and just go for fact finding. In inquiry role, then you need to apply your brain, allow the natural principles, allow the equity to prevail, fairness to prevail, and then after applying your brain, come out with a final report. Then manner of the inquiry into complaint. This is rule 7 of POSH rules. Subject to the provisions of section 11, at the time of filing the complainant has to submit 6 copies of the complaint. So if a woman reaches IC, she has to give 6 copies, 6 original copies with her signature on all of them. Now, after the IC receives these copies, within 6 or 7 working days, the complaint and its copy needs to be sent to the respondent. So within period of 7 working days, the copies would be sent to the respondent so that he is aware that there is a complaint which has been filed against him. So once the respondent receives this complaint, within 10 working days, he needs to file his reply. He needs to give a reply upon that complaint, whether he is guilty, he is not guilty, within 10 working days. This is why it is very time-bound procedure. This is why it is very important procedure, because for every step there is time given. For every step there is a definite period of time and it should not be violated. That's the reason that it gives the justice very quickly. Then complaint committee, while making an inquiry, definitely needs to take care of principles of natural justice. कोई bias नहीं होना चाहिए. Both the parties must get equal opportunity of being heard. So all these principles of natural justice are something which the complaint committee would take care of. And if at all there is complainant or respondent who are not appearing in front of the court for, let's say, 3 consecutive hearings. So agar 3 consecutive hearings pe you are not coming in front of IC, you are not giving them a reason why you are not coming, then IC needs to work. Then IC is also authorized to give an ex parte decision. Ex parte decision is that one party is absent and yet I have given my decision without hearing his side of story. Why I couldn't hear his side of story? Because he is not presenting himself in front of me. So if a person is absent for 3 consecutive hearings, ex parte decision can be given by the complaint committee. Then the parties shall not be allowed to bring in any legal practitioner. So if one party is allowed to bring a legal practitioner and the other party is basically IC, who might be someone who's not having any legal members, then principles of natural justice cannot be followed. So that's the reason, in order to maintain fairness, in order to maintain equity, in order to give both the parties equal opportunity of being heard, it is very important that there is no leaks, 3 people are not there, that day or that inquiry or proceeding becomes questionable. Then there are certain things which are certain cases basically, which also gives an insight as to what internal complaint committee should keep in mind while working for sexual harassment cases. So, first case is Ruchika Kedia versus the Internal Complaint Committee, Goa Institute of Management. Here, the court observed that Internal Complaint Committee was not constituted as per the regulation. So, it is very important that the complaint committee must compose, all the members must there, the quorum of 3 members must be present at the time of proceedings. Otherwise, it makes the entire proceeding questionable. And that was the reason this particular case made, the court said that no, your internal committee was not constituted properly. So we are keeping the report aside. Then another case is Bhuvan Chandra Pandey versus Union of India. It's an Uttarakhand High Court judgment, a very important judgment. So sometimes, because I have been working with IC very closely, so sometimes what happens whenever there is a case of sexual harassment, most of the times there is always this past involved. There is always people who were seeing each other, who were there together, or they have these kind of cases also. And then when these kind of cases, these kind of relationships basically, when they go sour, then the women most of the time come and complain that now I'm not okay with it. He's still stretching the thing, he's still making comments on me in the office, and I'm not okay with it. In those kind of cases, it is very important for IC to understand whom to believe, what to believe. And a very important jurisprudence of these kind of cases is that if you cannot substantiate, you cannot come to a conclusion that the girl is right or the respondent is right, both of them are not able to produce or corroborate whatever they are saying, they do not have enough evidences, then whom to believe? Now, this is one case which says that sole testimony of the victim is sufficient. So, we need to give the benefit of doubt to the woman. We need to understand that presumption rule is always in the favor of the victim. So, whatever is victim saying is the testimony which is sufficient. Now, it is for the guilty party to prove contrary. It is for the respondent to prove that whatever victim is saying is not true. If he or she is not able to prove the contradictory statement, then the sole testimony of the victim would be enough to make the respondent guilty. Then there is another case of Biba Pandey versus Punjab National Bank, again a very celebrated kind of a judgment, wherein the court says that IC has a jurisdiction to take cognizance of sexual harassment matters. But just because you can take the cognizance of sexual harassment matters, you cannot start working as moral police. You cannot start questioning consensual relationships. If two people are together with both of theirs consent, then IC is no one to intervene and question their behaviors. So, moral policing is something for which IC is not constituted. It is constituted only and only when there is something which is happening and the woman, the complainant, is not welcoming that behavior. So, consensual relationships, no cognizance from the side of ICC, because ICC is not the moral police. Then principles which are to be followed during investigation. As I already told you, principles of natural justice are something which at every point of time ICC would follow, and there has to be no allegation of bias on any point of time. So there is Ashok Kumar Singh versus Union of Delhi. The court discussed that there are ways to take cross-examination and emphasis, and inquiry should be based on principles of natural justice. So it is basically up to the members of IC to create an environment where they do not seem to be biased and they are not actually biased. So bias is something which is going to put a question mark on the credibility of IC members, and that bias must be internal, and the environment itself has to be non-biased, so that the complainant and the respondent, they get the idea that IC is going to hear to their matter in a very unbiased and non-prejudiced manner. Then interim relief, Rule 8 lays down certain interim reliefs also, although it is a very time-bound kind of the redressal mechanism, but still the time limit which is there is 90 days. The whole procedure can take 90 days, and 90 days time period is quite a big time period for any woman to be in that hostile environment. Specifically, if someone has filed a case, the environment is going to be very hostile. If I have filed a complaint against my boss and tomorrow I am going to sit in front of my boss for 90 days, it is going to be very difficult for me to survive those 90 days. So that is the reason that there is the provision of interim relief also, which says that the respondent can be stopped from being my reporting officer. So if my boss is someone who is the respondent, there are all provisions that I can ask ICC, at least meanwhile, whenever the final recommendation would come, it would come. But meanwhile, for these 90 days, kindly grant me an internal relief that I am not reporting to my boss. So this can also happen. Similarly, if the boss cannot be shifted, shift me from that particular position for 90 days. So there is always a possibility wherein the internal committee can restrain the respondent from the reporting on the work performance of the aggrieved woman, overwriting her confidential report and assign the same to another officer, and similarly restrain the respondent in case of an educational institution for supervising any academic activity of the aggrieved woman. So beyond interim reliefs, these are the recommendations which IC members can recommend in their report, which is final outcome of the proceedings. They can ask for written apology, they can give warning, they can deduct the salary, they can ask the person to carry out a community service or go for counseling session, to an extent that the respondent can be terminated from the workplace also. You can withhold the pay or increment, you can stop the promotion of the respondent, you can reprimand or censor the behavior of the respondent. So all these recommendations against the guilty are very much within the power of the IC. So if IC founds the respondent guilty, any of this can be recommended. Then if someone is not happy with the recommendation, there is a process of appeal also. So before IC, if the matter is disposed of after the day of disposal, within the 90 days time period, an appeal can be filed after the completion of inquiry, after the filing of recommendation. This is again a time bound process. So time bound process says the appeal needs to be filed within 90 days. Then there is the provision of Shri box. It's a very advanced kind of a procedure. Ministry of Women and Child Development, they launched this Shri box in 2017. Shri box is basically an online portal wherein you can go and click on this portal. There is a link also which I have provided. Just give me a second, I'll give you this. So this is a link. You can go to this link and you can or you can download it also. Then after downloading it, you can directly send the complaint to ICC, and this ICC is going to resend or rechannel your complaint to your respective department. So this is their lookout. They are going to find out which is your concerned department or ministry or workplace, and they are going to rechannel your complaint to that concerned department. And then you can check the status of your complaint also. You can go to the website and you can track what has happened in your complaint, whether the cognizance is taken or not. So this is a very progressive step which was taken. And then there is this let me show you this. This is how the Shri box looks. So this is the website. Go there, register your complaint, view the status of your complaint, track where your status has reached, what is happening in your case.
Madam, click on hide so that it will be hidden. That
Okay.
hide you right. Okay. Click. Okay.
Okay. Now
Now
just a
perfect.
second.
Heading was that. Now it's perfect. You can present.
Okay. So just a second.
Yes.
There is only one slide which was left. I just want to finish with this one. So this is a very recent case in August 2023. Basically, Supreme Court has given a case. In the case is Fernandez versus State of Goa. Why this case is important? Because 2023 aa gaya, 10 years almost have passed after 2013 act, and yet we don't have adequate formulation of policies. Yet there are very many workplaces wherein people are either not aware that this kind of legislation exists, or they are not taking it seriously. The compliances are not there. There are many workplaces wherein there is no IC. There are many workplaces wherein IC is there, but they are not having any complaints. Even though there are complaints, they don't know what to do with those kind of complaints, because IC members are not trained to handle those complaints in an effective manner. So the Supreme Court in this case once again said that it has been 10 years since the enactment came into force, and yet the implementation is very inadequate, and yet there are lot many things which can be done at the workplace from the side of employer, and it is high time that we start enacting the legislation with truest possible sense, and we understand the soul of the legislation. So that is how, and that is where I would like to leave with a thought that even Supreme Court is not happy the way the Posh is enacted. And being people who are working, being people who are associated with workplaces, it is our responsibility also to make sure that POSH is enacted, or one way or the other, we are spreading the awareness about what exactly is sexual harassment and how the law equips us to deal with it in a very effective manner. So that's all, I guess, from my side. If there are any questions, I would like to take those.
Thank you so much, madam, for the excellent presentation. Now I request dear participants, please, if you have any doubt or inquiry, please come ahead. Dear participants.
Rajkumar Pawar sir, please.
Rajkumar Pawar sir. Rajkumar Pawar sir, please.
I think by mistake he have raised the hand.
Dr. Fan
Fan.
Shukla sir.
Hello, good evening, Dr. Bedkar sir, Principal sir, Prashant sir, and good evening, ma'am. A wonderful presentation you have made and explained very well all the facets of, how a complaint can be lodged and governmental portals and everything you have talked in detail. Now, my one very simple question is, someone lodged the complaint in IC, and after certain duration, maybe because of some reasons, we don't know whether, the person himself or herself will consider that now it is not good to go with this complaint, or some pressure, external pressure comes to that person, and then she came and she said, I want to withdraw my complaint. But once it has reached to IC, and especially at institutional level, so what action we should do? Should we allow her to take it out back the complaint, or what exactly? What should be the role of IC over here? Thank you.
Okay, thank you so much for the question, sir. So, IC basically is given a mandate wherein the first choice of action must be to reach at a settlement. So if respondent and complainant, they are both willing to settle the matter, IC just have to bring it on record that the matter is settled and complainant do not want to take any further action, and that would be end of it. Against the will of complainant, against the choice of complainant that she wants to pursue with the case, IC cannot intervene and IC cannot keep on going with the case. So if the lady or woman basically tries to back out, IC will have to give it to her and definitely will record the reasons that this is the reason that we are stopping or we are not taking cognizance of the matter any further. But having said that, this happens in most of the cases. Women do take back their complaints and IC just put it in record, and there the case ends. So that's it.
Ma'am, in one of the case, both the parties were called and they have been questioned, and that time they made their stands.
Yes.
After the when we went for second inquiry round, over there she back out. So what exactly we should do? Because she was there, she was having a point, and the person was also having his own points in his way. So only the thing was, our judgment was this. So we asked for the next round, and then when we went for next round, they both she denied that we don't want to continue further.
That's what I'm saying, sir. There are provisions in the court wherein we talk about hostile witnesses, and there are talks about compoundability of offences, non-compoundability of offences. But in these kind of cases wherein we talk about IC, out of court settlement होते हैं sir, रेगुलर कोर्ट्स में वो अलाउड हैं, पर कुछ केसेस में कोर्ट आउट ऑफ कोर्ट सेटलमेंट भी नहीं करने देती. जैसे रेप में यू आर नॉट अलाउड टू बैक आउट. यू आर नॉट, once the case has gone to the court, the decision would come out whether the girl wants to go ahead with it or she doesn't want to go ahead with it. But IC is different. IC is basically a quasi judicial body. It is not a judicial body. We have our own restrictions. So IC cannot go ahead without complainant. If complainant wants to back out for whatever reasons, in one inquiry she was alleging that harassment happened, in next inquiry because of family pressures or because of work environment pressure she has bowed down to it, she doesn't want to go ahead, whatever the reasons are, IC has no power or authority to go ahead without her consent. Still we cannot say that in one time you have said that this has happened so you cannot back out, or even though you are backing out, we are still going to take the cognizance and we are still going to penalize the respondent. That is not how IC functions. IC has to bring it on record that parties do not want to persuade it and end it there. That is the limitation, that is the disadvantage, whatever you want to call it. But being an quasi judicial body, you cannot do or act the way an ordinary sessions court or civil court functions.
Madam, in such instance, should we take written this explanation for this from the candidate?
Yes, I would suggest you that it is always good, it is always concrete when you get it in writing that the female, the woman basically doesn't want to persuade the matter. It is always good to uphold the credibility of IC. So it is always nice to get in writing, get the statement recorded wherein this woman says that I am taking the case back, I am taking the complaint back, and then record the reasons and stop it.
Correct, madam. Thank you. Thank you very much, ma'am, for wonderful explanation.
You're welcome, sir. I think Dr. Gitika wanted to ask something.
Yes, madam, please.
Yeah, very good evening to all. And first of all, I would like to congratulate Madam Shivani, ma'am, for such a wonderful session. And being a working woman, I think that all the working women must have a knowledge about this act. And thank you so much, Dr. Bedkar, and all the organizing team for this wonderful, facilitation from your side to have a knowledge about this very relevant topic. Ma'am, as you stated that every employer is required and it is a mandate to formulate IC. Is it only for the industrial houses or for the educational institutions also? Is it mandatory for the educational institutions at the same time?
Madam, unmute yourself.
Just a
because I-
second. Yes. So, ma'am, there are two perspectives as far as the education institutes are concerned. So, we, the teachers, basically, we are employees. So, let me give your answers step by step. Every workplace which has 10 or more than 10 women employees, they need to have IC. Whether it is a public undertaking or a private sector or an industry or whatever setup you have, more than 10 women employees, then you are required to have an IC. That's the first answer. Second is, in education institute, we work in two capacities. One, we are teachers, wherein the university is the employee or college administration is the employer and we are the employees. Therein, between the employer and we, the teachers as an employee, POSH works. But when it comes to when it comes to students, UGC regulation is there of 2015. So if any harassment of female student or male student happens, whether it is from the side of teachers or whether it is from the side of classmates or fellow students, then it would go under UGC regulation. So I hope I'm clear with this. So as a teacher, we are employees, but between students and teacher, it is the UGC regulation which prevails, and it is in harmony, it is in synchronization with POSH Act. So they are very similar ground, but वहाँ पर जो IC होती है, उसमें there are student representatives also. So if there is any student complaining, then there is this IC which has to be composed by every college, every education institute, every इसको हम बोलते हैं HEIUG, Higher Education Institute UGC regulation for prohibition, prevention of sexual and redressal of sexual harassment. The regulation is of 2015. So that is where you will find a provision IC for students, which would deal with sexual harassment of students. And student is an agender word. वहाँ पर male student can be complainant also.
Okay, okay.
So that's it.
Right. And can you suggest any of the platform if somebody wishes to, get a certification or just to have a knowledge about this act? Is there any specific institution that you can recommend one can go through for a certification?
There are lot many courses which are happening around. Just give me some time, or I am guess Dr. Bedkar ke through I would be giving you a link. Okay, there are lot many institutes, but I haven't paid any heed ke kaun sa acha hai, kaun sa bura hai. So let me find some good institute for you, and I'll share the link with you. Either on the group or through sir, you can get it.
Yeah, thank you so much. Thank you.
Thank you.
Any other questions?
Dear participants, again you have any query, please come ahead or we move forward. Dear participants. So thank you Dr. Swami Shukla sir, Honorable Dr. Gitika madam for your nice queries. And madam, you have answered it very clearly. So thank you so much. Now I request the chief organizer of the series, Honorable Principal M. Bedkar sir. Sir, please come ahead and have some words regarding today's session. Please go.
Thank you, Prashant sir. And today's resource person, Shivani Verma madam. From last more than 45 minutes we are listening her. The explanation was very perfect. PPT was very clear, and every point we have listened from her. How the internal POSH Act is there, how the amendment of it is done when there are no two women's. After that, what is the judicial area? So these things are too much cleared by her. How internal committee works, how many members are there, so how the process is there, and how many duration there should be for justice to that victim, and also how we can withdraw the case in what happens. So all these things are so much cleared by her. Those who are here as a teaching community or any other members, those who are from out of teaching institute also, how they form internal committee if there are 10 women or more than 10 women in the institute. So this basic information is also given by madam. Actually her webinar session was so late, but because of some problem I requested her madam to join here. So she accepted our invitation and prepared very nicely. I think this topic is also her teaching topic because she is law professor. So thank you madam for a best presentation, and it will be circulated in our all women employee and the girl students of our college. Thank you for the best information. Thank you to Dr. Shanand Shukla sir also, who discussed very perfectly as every day. Thank you sir. And thank you to that madam who have explained here. What she have queries, she will write in message box or on that feedback. I will give the links and required information through you to her. Thank you.
Thank you so much. Thank you, sir.
Kindly
Should
wait
I?
for the vote of thanks. Just wait a minute.
Okay.
Thank you, sir. Now I move to the vote of thanks. Shri Kumarswami Mahavidyalaya Ausa, District Latur, is organized well. The equality issue. Today we have completed 266th day of the session. And the topic for today's presentation was the sexual harassment at workplace, how to prohibit, prevention and redressal in law. Now this topic have presented by Honorable Dr. Shivani Verma Madam, very clearly in a simple verse, and cleared all those details regarding the sexual harassment and the POSH Act, where Madam have what are the provisions, also explain what are the provisions in the laws, how does this POSH Act works, then how to prevent the crimes regarding the sexual harassment. All those points have covered in your lecture so nicely, sincerely. So I am very, very thankful to you, madam, on behalf of the organizing committee members, because you accepted our invitations and be parted in the session. So thank you so much for your wonderful presentation. I thank the chief organizer of the series, Honorable Principal M. Bedkar sir. Also thanks the colleague from my college, Dr. Sanjay Kale sir, Honorable Prakash Karar sir, Praveen Kamble sir, Vocational Supervisor, Honorable Praveen Udge sir, and others. Special thanks to Dr. Swami Shukla sir and Honorable Dr. Gitika madam, who have asked nice queries in the session. And heartily thanks all those dear participants who join the series regularly. Also encourages us to run the series. So thank you so much once again to you all. Now request to you all, please fill the feedback link which is given in the chat box.
Thank you,
With the
madam.
kind permission
और
of the
सभी
chief
को
organizer,
गुरु नानक जयंती की बहुत
session
सारी
is over.
शुभकामनाएं. गुरु नानक जयंती की शुभकामनाएं. थैंक यू मैडम.
Thank you once again, Honorable Shivani madam. Thank you so much.
Thank you so much for having me. Thanks a lot.